To provide you with some background, several years ago, Mr. Pickle called our offices with some challenges faced by the county unit. Our attorneys immediately advised him that they were very limited in what they could do, but they could provide him with some information right away.
What did Matt tell me when I first contacted it about our problem in March 2020? First, let me explain what our problem was. After being asked to serve as NCAT Secretary-Treasurer, we tried to update our bank records. It took an entire year because of inadequate support from Matt. Our banking problem had two parts. First, we needed a document from Matt or the state saying that we were a valid organization. Second, we needed to know what kind of organization a county unit is in order to get an EIN number from the IRS. This is the email Steve Finsky sent me on March 25, 2020. Here's where he argues against the idea of county units being government entities. If a county unit were a joint powers, it would be a governmental entity and would have the problems Finsky lists here. Here Finsky says he favors county units being a 501c nonprofit and that he will be working on the problem if we aren't in a hurry. That was March 2020, and so I waited and waited and waited. By December that year, I had decided I couldn't wait any longer and started again trying to figure out on my own the answers to the two parts of the problem.
County units are legally independent entities from MAT, but we value county units. We send our directors to their meetings, we send staff when requested, and we work together in other ways. Matt tried to help NCAT at that time and until early September 22, and up until early September 2022.
Did Matt try to help us? We never got a document from Matt saying that NCAT is a valid organization. We had to figure out on our own that NCAT, like most county units, are unincorporated associations, and we then obtained an EIN from the IRS on that basis. We had to figure out on our own that since NCAT is unincorporated, the state won't issue a document either. The bank then told us that we only needed to give them a copy of our bylaws, and our banking problem was over. It only took a year. I don't think a county unit should have to hire an attorney to answer general questions like these. On the last point here, Matt's bylaws provide only two ways for amendments to Matt's bylaws to reach an annual meeting for a vote. One, the Matt board can propose an amendment. Two, a member township can propose an amendment, but it must first be adopted by a county unit and then approved by the Matt board. The only reason I can think of to give such gatekeeping power over members to county units is if the county units themselves constitute a special class of membership in Matt. Here's where Finsky in a November 2020 email said that for the purpose of being paid dues, county units have been treated as members. And here's where Finsky says he doesn't think Matt is obligated to help county units. Matt originally incorporated in 1934 with the purpose of creating county units. In 1983, Matt celebrated its 50th anniversary. It seems to me that Matt has a moral obligation to help the county units it created, unless the county units were given proper notice that they were being orphaned. Here's my January 25, 2021 email in which I think that Finsky is still working on the problem. It was not until after NCAT passed its September 12, 2022 resolution that I discovered that Finsky had decided by September 4, 2020 not to help us, and that he had failed to inform us of that decision. More on that later.
We spent years working with them. We provided a few options and possible solutions to Mr. Pickle. It is unclear whether those options were communicated to the NCAT board or any of the towns in Norman County.
This is not the first time Krueger says I was provided with options prior to the NCAT resolution being passed. The specific option he is likely referring to is that NCAT become a joint powers governmental entity. But what are the facts? Finsky provided so-called options to the Matt board to consider at their board meeting 3 days after the NCAT resolution was passed. Here is Krueger's October 19, 2022 letter, which says that the Matt board had voted a plan. The reader is here led to believe that the Matt board's voted plan was passed prior to the September 12 NCAT resolution. Here are the MAT board's published minutes for the meeting of July 21st. And here is where that meeting voted to ask Fenske to come up with a plan. Here's what Fenske emailed to the board members on September 12th, rather than attend the meeting that Krueger had asked us to call and invite him and Fenske to come to. Here's option number 1, that county units form a joint powers governmental entity. 3 pros, 7 cons. The pros consist of 27 words and the cons 124 words. The only reason to write up this option in this way is if you are arguing against it. Option 2, county units being part of MAT. 2 pros, 6 cons. 19 words for the pros, 98 words for the cons. Option 3, the last option. And that option is, we have no clue what a county unit is. This must have been the option Fenske wanted the board to vote. We may call it the do-nothing option. Under this option, county units would never be able to get EIN numbers since they wouldn't know what type of organization they are, and thus they would never be able to get a bank account. But that memo sent out on September 12, 2022 was really authored by Fenske on September 4th, 2020. It therefore shows that Fenske had decided not to help NCAT by September 4th, 2020, but he never told me so. During a November 11 Zoom meeting, Krueger said that Fenske had provided options. Wayne Lee then took this memo and drew attention to the pros and cons. Fenske then declared that NCAT was not supposed to have that document. Thus, when did Fenske ever provide me with options? Note who that memo was addressed to. David Hann left MAT in late 2020. Krueger came on board in March 2021. Thus, there is no way that Fenske authored this memo in 2022. Here are the document properties showing that Fenske created it on September 4th, 2020 in 2 hours and 15 minutes. Here is a list of all the emails I have received from Fenske that I can find. The one on March 12, 2021 is on an unrelated topic. Thus, we must zero in on the 2 emails from December 28, 2020. The second email asserts that no county unit knows what kind of organization it is. The first email sent sample bylaws and also stated, quote, one option is to treat the unit as a government under a joint powers, unquote. Fenske then went on to spell out the complicated problems with this approach. No other option was given. But 40 minutes before Fenske sent that email, I had emailed him a PS asking him whether MAT had been an unincorporated association prior to 1979. Thus, I had already figured out, or almost figured out, that NCAT was an unincorporated association. Talk about the complex, problematic joint powers supposed option at that point would not have been persuasive, given that there was a much simpler solution at hand.
In August 2022, Mr. Pickle's communication to us became disrespectful and confrontational. Our staff personally reached out to each NCAT board member in August 2022 to explain that we would not work with Mr. Pickle on the issue and would talk about the issues that remain for the county unit only with the NCAT board's other 4 members.
So according to Krueger, all 4 of the other NCAT board members were contacted in August, telling them Matt would not be involved in any discussions that included me. Here are the facts. Krueger asked me on August 29 to call a meeting and invite him and Fenske to come and talk with us. I sent the invitation to him on August 31st. Most likely this excuse of not being able to talk with me wasn't raised to the other NCAT directors until the week before the September 12th meeting. Here's Krueger's August 29 email asking us to call a meeting. Here's my August 31st invitation, sent at 5:48 p.m. Let's compare Krueger's current timeline of all 4 other NCAT directors being contacted in August with what he said in October, and what the cease and desist letter said on September 23rd. Krueger in October blamed his non-attendance of our September 12th meeting on disrespectful emails I sent after the invitation. According to the cease and desist letter, the decision to no longer talk with me was made by September 1st. Here's Krueger's October 19 letter. Here's where Krueger asserts that I sent out disrespectful emails after the invitation. Here's the September 23rd cease and desist letter. Here's where it says that 2 of the NCAT directors were told on September 1st that Matt wouldn't talk with NCAT if I was involved. I can't find any disrespectful emails that I sent after 5:48 p.m. August 31st, and by the time Finsky called 2 of the NCAT directors on September 1st. We asked for copies of those emails in order to prepare our defense for the January 5 hearing, but never received any. Neither did we receive a reply. Perhaps Krueger knows that the timeline he gave in October doesn't work, and thus chose to push the phone calls in question back into August. But that won't work either. The best course is to always tell the truth. Otherwise, you'll end up contradicting yourself at some point.